Hey, shalom, 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 shalom. First of all, giving all praises to the God of our forefathers, the God of Abraham, God of Isaac, God of Jacob, whose proper name is Yahweh. All praises due to Yahweh, why Yahweh Shah. Um, I begin all things with the illustrious name of Yahweh, and I do realize that without him, I would actually be able to do nothing of myself. So all glory, all power, all praises is due to the Most High Yahweh. And everything that I'm about to say in this video is strictly for educational, informational, entertainment purposes only. It's not to be taken nor misconstrued as legal advice. So knowing thus, if you use any of this information, you fall flat on your face, is your own fault because you did not research the information that I give you. This is strictly for educational purposes only. And so, by the way, I'm gonna tell you, I'm gonna ask you, out of the kindness of your heart, as you come into the room, um, show some love and give a thumbs up. I'm actually putting my energy, my time, my research into this, and so to not destroy the UNI verse, you definitely want to give back. If that simply means giving a thumbs up, if that's all you could give, I contend that you could actually shalom, good brother Joe Moore. I contend that you could actually give more if you dig deep. Most of you got short arms and deep pockets, but hey, this is quid pro quo. This is the law of the universe, right? So, meaning that in order to inhale, you got to first exhale. You got to give to the UNI verse if you want the UNI verse to get back to you. When you don't do this, you're destroying the universe. And so either you're here giving as me, I'm here as a servant, I give, or you're taken away. And if you're taken away, you're aiding to the destruction of the universe. So you can actually donate. The links in the room, cash.me, Tyler Doc Shaw, on Cash App, or of course, you could actually donate on my PayPal channel by visiting the website. And so this video comes about courtesy of the good brother Tony making a donation. Now he's actually he has some situations going around with a colorable court, and he's actually done some time behind that. Believe it or not, down in Florida, they're really ruthless. So you could actually thank Tony for this. This video comes about courtesy of Tony. He has actually an up and coming court date this up and coming Monday, and may the spirit be with him, and may he, for educational purposes only, learn something from this particular session that will help him. And I know firsthand it's actually going to help many of you. But the problem is, most of you won't give. You just want something for nothing. So again, as you come into the room, if nothing else, at least give a thumbs up to show your appreciation. Again, the channel's not monetized, so I'm not benefiting, by video hits or anything of that nature. But hey, I'm giving you my energy, giving my time, giving my research. You should give back. That's the natural law of the UNI verse. So here's some right knowledge that I'm providing for free. So at least, again, give thumbs up so that more people could actually come to the channel and be inspired and see that, hey, this does work for those that truly apply it through the spirit. And since I'm giving myself by giving this right knowledge from the UNI verse, then you should give back. Again, this channel's not monetized. Again, the donation for the Cash App is in the room, cash.me at /$ Tyler Doc Shaw. It would be greatly appreciated. So this right knowledge is about a special appearance that everyone should study. And since that is one main, or should I say one of the main ways to assert our rights in a court, be it colorable or what have you, the first thing after status is established is to challenge jurisdiction. I don't just walk into a court I appear specially. So the first thing, one of the main thing, and a lot of you think you understand this. I talk to a lot of people, they swear, well, I understand this. Man, shut the hell up, man. Why don't you shut up and learn? It incenses me, man. If you're a know-it-all, why are you calling me anyways?
Join the meeting.
How did they get in the room? Who's that? I don't know how you managed to get in here, Terrence, because I didn't send you a password. But nevertheless, so one of the main things that you really need to learn how to do is to challenge jurisdiction, right? The other is a counterclaim. 99% of the time for me is a counterclaim, which is always a conditional acceptance. And then there's something known as, that I've used before, as an optional appearance, which is appearing as a third party intervener. Who are you? Are you Tazadak Shah? No, I'm actually here as intervener to challenge all charges outstanding. So I never go in as a defendant, because I know that my father nor my mother named me defendant. So the defendant is not me. I'm here as intervener. I'm here as Tazadak Shabe, intervener, to handle all charges outstanding. But again, this is only for secure party creditors. A lot of you know-it-alls. You think you could do it. Oh, I'm not a secure party creditor. I could do it. Will it work? I'm not a secure party creditor. It's only for secure party creditors. Become a secure party creditor now. What are you waiting for? And since we have UCC liens as a secure party creditor against the debtor straw man, and so claim to be secure party creditors, i.e., the holder in due course, me being a secure party creditor, and thus challenge the state's title to the debtor straw man, the all capital letters fiction. That's what many of you are. That's your status. You're a ward of the state. You're a dead thing. So, good brother Tony, I hope you're. Is Tony on the call? Let me see if he's even on the call here. Hope he's on the call here. You on the call? Yeah, there you go. There you go. So, good. So to Tony and all others under the sounds of my voice, right? If you're not a secure party creditor, for educational purposes only, of course, right? You can use what is known as a special appearance to challenge the court's personal jurisdiction. But the SA, when I say SA, I'm not talking about so-called Mexican, right? I'm talking about a special appearance. Let me make that abundantly clear. The SA should be accompanied with your affidavit of truth and other documents to support your claim. Also, I want you to take note that asking for benefits from the court, such as asking for a continuance or arguing the case, constitutes general appearance, which means they now have jurisdiction over you, and ends your special appearance. It ends your SA. Do you understand? Do you understand? Next thing, one should also file a special appearance for educational purposes with the clerk of the court, usually at least 2 weeks before the arraignment, and send a copy to the DA as well. Why are people not doing this? Why are you contacting me and you got court the next day? You got court 2 days later. Now, there are 3 ways that the court acquires personal jurisdiction. Number 1, physical presence at the time of service. Generally, even if the presence within the jurisdiction is temporary. Number 2, you should be writing these down. If the party lives within the geographical area of the court's jurisdiction. Number 3, any party may consent to personal jurisdiction of a court which tries to assert personal jurisdiction over him or her, even if he or she does not reside within the geographical area that makes up the court's jurisdiction. Now, the way that I understand this, good brother Tony, right? Is that the courts with the yellow fringe flag have only jurisdiction over those residing in that state, which actually makes you a corporate ward status. So they only have jurisdiction over those in a corporate state and not those that domicile in a state of the union. So if you've actually filed a declaration of domicile, does that mean that you're a state resident? Res, thing, identified, resident, a thing identified. A thing is a person, which is a fiction, which is a debtor, which is a strawman. Au contraire. Case in point, right? Attaching your declaration of domicile to your special appearance might be one way of claiming not to be under the corporate state's jurisdiction. Do you understand? Do you understand? Now let's talk about special appearance. Because I talked to the good brother Tony over the phone, and I'm not sure if he was clear. And my word is my bond. I told the brother, hey man, I'll do a video for you regarding this subject matter. Did I say it, Tony? And here I am, man of his word. So, a special appearance is some overt act by which the defendant comes before the court to either submit or to challenge the court's jurisdiction. That's what that's what an appearance is, right? That's what an appearance is. An appearance, a coming into the court by a party to suit either a person or through an attorney, whether as plaintiff or defendant. The formal proceedings by which a defendant submits to the jurisdiction of the court. The voluntary submission to a court's jurisdiction. That's what an appearance is. When someone sends you an offer in the mail and say you are to appear on such and such date, and if you just show up, you just granted them jurisdiction. I'm appearing, specially, not generally, as intervener. So a special appearance is the concept within the United States federal rules and civil procedures that allows a person who has been served a summons a chance to appear at the court's proceedings with the special purpose of challenging the extension of personal jurisdiction by the court. So now, Tony, you're saying that this black robe, saying that they already have jurisdiction. Au contraire, he's playing semantics with you. So, good brother Tony, by challenging such jurisdiction in a special appearance, the party is challenging the court's right to hear the case against him or her based on the lack of personal jurisdiction. If you don't have jurisdiction, I'm going to be leaving. So if the argument made during the special appearance is effective, then the court will have to dismiss the case. This is what I'm trying to get you to understand, good brother Tony. Do you follow me? This is what I'm trying to get you to understand. Don't let them talk you out of your victory. You're just an aggrieved man, showing up as intervener to handle all charges outstanding. Now, personal jurisdiction refers to the right of a court to hear a case based on certain qualifications regarding the court and the party, in this case, Tony. This type of jurisdiction is generally asserted in one of three ways, my good brother Tony. The first, again, is the physical presence at the time of service. Generally, even if the presence within the jurisdiction is temporary. Number two, because repetition is the mother of learning, I'm repeating these again. Personal jurisdiction may be asserted if the party lives within the geographical area of the court's jurisdiction. And number three, any party may consent to personal jurisdiction of a court which ties or tries, should I say, to assert personal jurisdiction over him or her, even if she or he does not reside within the geographical area that makes up the court's jurisdiction. Now, normally, a man or a woman submits himself or herself to personal jurisdiction by physically entering the jurisdiction. My question is, did you do this without saying I'm appearing specially as intervener? If you do, you can't argue jurisdiction. You gave it to him already. A special appearance, again, is an appearance by a party within a court's jurisdiction that is conditioned on not submitting himself or herself to such jurisdiction, good brother Tony. Do you understand? For example, right? If a man lives in Florida, right, is served with a summons through the mail. Let's say this guy's name is Tony, stating that he must appear in a Florida court. He may want to challenge the court's assertion of jurisdiction over him. Do you understand, Tony? Do you understand? So in order to do this, he may have to appear in court, which presents a problem, right? Watch this. Watch this. As setting foot in Florida court would validly subject him to the jurisdiction of the Florida court. Now, watch this, important part. By making a special appearance, Tony may enter the state with the sole intention of appearing at court to contend that he may not be summoned to this Florida court because they do not hold personal jurisdiction over him. Do you understand? Does everyone get that? And more importantly, Tony, do you get that? Do you get that? That's the question. Do you get that, Tony? Now, any party, good brother Tony, can appear in propria persona or through an attorney or a duly authorized representative. Who are you? Me? I'm the authorized representative for Tazadak Shabe. Then why is Tazadak Shabe? Birth certificate? He's right here. He's right here. And that may sound trivial, but he's right there. Then who are you? Again, I'm his authorized representative. I'm here as intervener. See, the party need to be physically present, right? In most instances, an attorney makes the appearance on your behalf. Why? Because you are a minor in the eyes of the court. You are an incompetent ward of the state. You are an infant. You're like a newborn. You're not intelligent enough to present your own case, so they give you a representative that is authorized to go on your behalf. Well, I, man, have the capacity of being authorized to represent Tazadak, the debtor's straw man. So an appearance can be made by filing a notice of appearance with the clerk of the court. And the plaintiff, which states that the defendant will either submit to the authority of the court or challenge the jurisdiction thereof. I choose the latter. Now, an optional appearance is entered by a man or a woman who is intervening in the action to protect his or her own interests, though not joined as a party, such as a secure party creditor. That's an optional appearance. Hey, I'm here as intervener. Now, the two most common categories or appearance are general and special. You should be writing this down, Tony, and I hope you study this video, brother, because you don't have a lot of time. I didn't have to do this. Now, any action by which the defendant recognizes the jurisdiction of the court constitutes a general appearance. Understand that. And so this actually unqualified submission to the court's personal jurisdiction over the defendant and is treated as the equivalent of a valid service of process. So by making a general appearance, the defendant agrees that the court has power to bind him, to bind her by its action, and waives the rights to raise any jurisdiction defects. Case in point, by claiming that the service of process was improper. So the defendant also waives the objection that the case is brought in the wrong venue. Once they get jurisdiction, you're pretty much done. The defendant does not, however, waive the substantive right or defense, such as the claim that the court lacks jurisdiction over the subject matter of any case or authority to hear the particular type of case. Case in point, bankruptcy court will not hear personal injury cases. So a special appearance, right? A special appearance is one made for a limited purpose, a limited purpose. It can be made, for example, to challenge the sufficiency of the service of the process. They might have sent out a process service. Did he properly serve you? Might have sent out a sheriff. Did he properly serve you? But most often, a special appearance is made to challenge the court's personal jurisdiction over the defendant. It prevents a default judgment from being rendered against the defendant for failing to file a pleading. Do you understand, Tony? You really got to get this, brother, because they're trying to send you up the river. A default judgment is automatic loss, family, for failing to answer a complaint properly. This occurs with many of you all of the time. So Tony and all others under the sounds of my voice, right? When the defendants make a special appearance, no other issue may be raised without the appearance becoming general. Do you follow me? They can't proceed. Once the court's jurisdiction is challenged, they can't proceed until jurisdiction is proven. They're trying to proceed. I object. This is why we got to take in a court report. Well, Mr. Tony, you're being charged. I object. Let the court show jurisdiction. Where's your delegation of authority order in writing? So if a party takes any action dealing with the merit of the case, the parties is deemed to have made a general appearance and submitted to the jurisdiction of the court. Question is, have you done this? If a challenge of jurisdiction is successful and the court agrees that it does not have personal jurisdiction over the defendant, it would dismiss the actions. They won't always tell you why they dismissed it, but this is why. So if the court finds against the defendant on that issue, the decision can be later appealed. So we want them dismissed with prejudice. So the right to make a special appearance is almost universal. Doesn't matter where you are. Doesn't matter if you're in Canada. Doesn't matter if you're in the UK. It's almost universal unless they've abolished it with some statute. Now, federal rules, federal court rules, and states have adopted the federal rules of civil procedures, have eliminated the distinction between a general and a special appearance. So instead of challenging the court's personal jurisdiction in a special appearance, a defendant can do so by use of a pretrial motion to dismiss the case or the cause of action, or in an answer to a complaint. A removal proceeding, Tony, in which a defendant asks to have the case move from state court to federal court, is regarded as a special appearance. Do you understand? So what I'm saying to you, good brother Tony, you told me all the judge is trying to railroad you and all of this. Move it from state to federal. Do you follow me? Move it from state. Where is he at? I don't even see him in here. I'm about to end the call. I don't see Tony on the call, man. Am I wasting my time here or what, man? I got a lot of things I could be doing, man. I don't even see him on the call, man. Are you still on the call, Tony? And I actually was going to show you guys an affidavit, but this guy's not on the call. I'm really wasting my time. See, I got better things to do with my time, man. I didn't have to do this, man.
Keep going, brother. It's all good.
Yeah, it's all good for you, but not for me, man, because I got a lot of other things that I could actually do, man. This man has a court date coming up Monday, man. A serious one that he might be looking at some time. So, I really, sincerely from the bottom of my heart was trying to help this dude. He didn't donate to me for this, man. I mean, donate for me for phone coaching. I'm just trying to give love, man. But nevertheless, man. So, and this works for most of you in any kind of so-called civil proceeding. Doesn't really matter know what the charges is, man. One of the first things you want to do is establish the status of the court and then challenge subject matter jurisdiction, challenge personal jurisdiction. If jurisdiction can't be proven, they can't proceed. Don't let them bluff you because this is what the law states. So again, a removal proceeding in which a defendant acts to have the case moved from state court to a federal court is regarded as a special appearance. So if you got a jackass black robe that keeps denying all of your motions, get the proceedings moved from a state court to a federal court for educational purpose, or recuse the judge. I'm gonna go over a quick motion on how I've actually recused a couple judges before. Now, delay or failure to appear. This is where a lot of you go off, right? A defendant who fails to appear in court pursuant to a service of process means you've been properly served. You're gonna have a default judgment against you. So don't come to me and ask me to help you with that, man. If you got a default judgment against you, you didn't show up. And you could be held in contempt. Not only will you lose, but you could be held in contempt. I mean, they could throw you in the joint, man. Now, by the way, one could probably also appear conditionally by telling the black robe, I conditionally appear as defendant upon proof of claim that I am the person spelled in the all capital letters name of that original charging instrument. So by doing that, my good brother Tony, you fulfill your promise to the court without admitting that you are the defendant, strawman, debtor, slave, and without refusing to admit to be the strawman, which can be considered, if you admit to being it, dishonor. Do you understand? Now, if the court overrules your special appearance, as a lot of these black robes trying to do, then it'll have personal jurisdiction. However, you'll be able to appeal that decision, which is why you can't even stop me where I'm lying at, Terrence. I always tell people to go in with a court reporter so they don't get railroaded. If you don't have a damn court reporter and the proceedings are not recorded, how are you going to get an appeal? You're not going to get an appeal. So you might want to spend that fiat and get that court reporter for educational purposes, man.
$200 or $300.
How much?
Maybe. About $200 or $300, maybe.
So sometimes it's 150, man. I guess that depends on over there, man. I don't mess with Texas, and I can see why they say that because they railroad you guys over there. You see what I'm saying? I don't mess with Texas, and I mean that from a different, like, I can't rock with them, man. They want to railroad you guys over there. $3 for a court reporter. Where they gonna be there all day for a week? So first things first. Now let's go over quick motion to recuse the judge, because I told the good brother I would do this also. My document open up here. Very short. And so one of the other things people don't want to do, don't try to sound all damn intelligent. Write all these damn long motions and so on and so forth. The shorter, the better. What was you saying, Terrence?
I think the brother texted in, he's on YouTube.
Yeah. He's on YouTube, but he had disappeared for a minute. I saw him over there. I saw
Okay.
him over there at the beginning of the call about, I was also asking him a lot of questions to which he wasn't responding. So motion to recuse the judge. I was, talking to him over the phone. Very simple. Okay, motion to recuse the judge, state of Florida, county of whatever. You know what I mean? Prosecutors, the state of whatever state they're in. The accused. I will put my name right here, Tony Montana. Case number right over here. That's all it takes. That's the heading right there. Go down. Motion to recuse the judge. This is the title of my motion. And look how short it is. Now comes the accused, Tony Montana, respectfully requesting this court to recuse Judge Jackass Bar Attorney from this case. Why? He's been prejudiced against me. It's been proven that he and the attorney has actually been prejudiced against me. I go down. Now I give reasons why this motion, that's the whole body of the motion right there. So now I'm just saying why my motion should be granted. This motion should be granted, number one. The accused insists that his right, me being the accused, be protected and observed in all court proceedings. How can they deny that? Number two, the accused has opted to exercise his rights to proceed in propria persona with this case. Now, again, everything that I'm going over here is in my books. Go to the website, www.truedisciplesofchrist.org/shop. You can get the books and DVDs because learning this language is really what helps you out. Number three, the judge was illegally practicing law from the bench by defrauding the defendant of his power of attorney by entering a plea. They often do this. Well, you're not guilty. Okay, roger that. By entering a plea on the defendant's behalf and over the defendant's objection. I object. You enter a plea from me. I object. For the record, I object. Number four, the judge failed to identify for the defendant the constitutionality, valid jurisdiction under which this case is being tried. Okay, you don't want to tell me jurisdiction, Black Roll? We're going to dismiss this. I'm going to recuse you, or we're going to dismiss it. And finally, number five, the judge claimed that this was a statutory case. And when asked for the rules of criminal procedures for statutory case, there's no such jurisdiction. The defendant was referred to the Motor Vehicle Code. No such rules of criminal procedures exist within that code. Then I end it. Respectfully submitted by Tazadak Shabe and propria persona. That's it. That's how you recuse a Black Roll. That's how you recuse a Black Roll. Now, on to special appearance. Let's get it. Alrighty then. Now we challenge this court's jurisdiction. That's why I'm reading on this one, man. Since you won, you can help me out, Terrence. A headache from all this reading. Okay, State of New York, Circuit Court, 8th Judicial Circuit for Kings County. State of New York is the plaintiff. The defendant, or should I say the respondent, Tazadak Shabe, in this case, Tony Montana. Then we have down here, Jackass Attorney. Notice, not a motion. Attorney for alleged plaintiff. Addressed to the State of New York, Jackass Attorney. Jurisdictional challenge with affidavit. So what's going on here? After I challenge the jurisdiction, I also attach an affidavit. Why do I attach an affidavit? The maximum law states an unanswered affidavit stands as the truth, which means they got to answer me. They don't want to answer me. I hear people say all the time, they didn't answer me. They didn't respond. Well, roger that. That's a good thing, isn't it? If you know the law. An unanswered affidavit stands as the truth. They could dismiss a motion. You can't just dismiss an affidavit. Why? An affidavit has an oath attached. That means you swear you affirm. Do you understand? So Tazadak Shabe, by limited appearance to this matter in this court of record, with clean hands, without prejudice, and with all rights reserved, including UCC 1-308, in dealing with this court and proper per suri juris, not pro se. So that means I'm coming in propria persona. Islam Moore, you know what it is, 5 on the left, 2 on the right. Shalom to the Israelites. So have not seen any evidence that proves that have the liability for the all capitals letters name above Eben initial challenge the personam standing juso and subject matter jurisdiction. The Supreme Court case. Here's a case number right here. Might want to write this down, good brother Tony. 1795 Penn Holloway, Donahue, administrator, 3 U.S. So it defines the governments or corporations. In as much, every government is an artificial person. I can't make this up. Go look this case up for yourself. Truth is right there before your eyes. So all government is an artificial person, an abstraction, and a creature of the mind only. It doesn't really exist. It only exists in your mind. A government can interface only with other artificial persons. This is why they strive so damn hard to get you to admit to being the name on the driver's license, the name on the birth certificate, the name on the social security number, and so on and so forth. Because you have to come in the capacity of an artificial person for them to do anything to you. You got to consent. The response from the party petitioner plaintiff, a certain proper jurisdiction throughout this case must be made on a point-by-point basis. What is meant by that? That means if they fail to answer just one question, then they haven't answered my affidavit. It has to be answered on a point-by-point basis. For all moving parties, petitioners, plaintiffs, actions, filing the motions, and true and correct in relations to the proper state laws, codes, regulations, statutes used to conduct this case, that proper jurisdiction was always maintained from the record, including that incomplete summons. And here we have another case law right here. Westfield versus Catholic, Dotrice Lansing, 279. I need to read all of that right there. Motion of summary disposition, just like the alleged defendant did in this case. The United States Supreme Court has stated the challenge of subject matter may be raised at any time, so it's not too late to raise it, Tony. It is never stated by what form. And Crook versus Applebee's of Michigan, Inc. Affidavit unrebutted. Affidavit unrebutted affidavits and affidavits unrebutted letters, including declarations of intent to Richards Township, showed proof containing in the pleadings that they rebut the plaintiff's prima facie claims and grounds for entitlement in the summary judgment, contrary to jackass attorney unverified statements that the plaintiff, because nothing that the attorneys say is going to be verified, right? Because he wasn't there. He's a third party. So he doesn't even talk to me. Each time he try to speak, I'm going to object. That's hearsay evidence. The only way it could get into the record is if you don't object. Prima facie facts still prove jurisdiction. The court will lack jurisdiction, being that there is evidence to support the improperly contrived subject matter by proper legislative process, that the 11th Amendment of the United States Constitution remove all judicial powers in law, equity, treaties, contract, and the right of the state to bring suit against the people. Therefore, the defendant now challenged the jurisdiction of the record. Once jurisdiction is challenged, good brother Tony, it must be proven. Don't let the judge swindle you. There's a case law right here. Higgins versus Levine. Once jurisdiction is challenged, it must be proven. All of you should be challenging jurisdiction for educational purposes. Mere good faith assertions of power and authority, jurisdictions have been abolished. Owens versus the City of Independence. House Resolution 1491, 1933, and McDonald versus the City of Chicago, that brought the 14th Amendment subject up. If we actually consider, assume the presumed by the government, to the 14th Amendment citizens, and the implication for us obligated obligated to leave us alone and not apply the government's administrative law to us. Standing must also be proven to show jurisdiction. So they got to show that they have standing. In order to bring a case to court, litigants must have standing to sue. In order to have standing, Supreme Court doctrine requires that the parties have an injury in fact. Where's the injured party, Terrence? Who did you injure? Salakia, not Terrence. Tony, who did you injure? Where's the injured party? States right here. I'm giving you the law. Supreme Court. This injury must be specified and concrete rather than speculative. So where's the injured party, Tony? An abstract. Standing requires the violation of a legal right and causes damages. A plaintiff must allege personal injury fairly traceable to the defendant's allegedly unlawful conduct and likely to be redressed by the requested relief. Allen versus Wright. Should be writing this down, 468. To gain standing to bring an action, a plaintiff must allege a distinct palpable injury. Wolf versus Selden. Case law again. To gain standing to bring an action, the plaintiff must allege a distinct and palpable injury. Here it is again. Fernandez versus Takata. See, I mean, case law after case law after case law. And guess what? These peoples is actually won based on this premise. The Lee Cleveland Cliffs majority also held that a litigant must meet London standing requirements, regardless of whether the litigants expressly created a cause of actions or conferred standing on the litigant, because although the legislative has the power to create causes of action, it does not have the power to expand jurisdiction or authority granted to the courts by Michigan Constitution. See Michigan Citizens versus Water Convention case law, right? Explain and show how the action of this kind is authorized. Statute, Martin versus Sanded. Here's another case law right here. All of these case laws, Tony, you should study this video and write them down and put it into your challenge of jurisdiction for educational purposes only, of course. In cases where the court is conferred power to adjudicate by virtue of statute, the court's jurisdiction is strictly limited by statutes. Do you understand? In a court of limited jurisdiction, whenever a party denies the court has subject matter jurisdiction, it becomes the duty and the burden of the party claiming that the court has subject matter jurisdiction to prove evidence from the record of the case that the court holds the subject matter jurisdiction. Emphasis added, Tony. All orders or judgments issued by a judge in a court of limited jurisdiction must contain the findings of the court showing the court has subject matter jurisdiction, not allegations that the court has jurisdiction. Do you understand, my good brother Craig? Do you understand, William? Do they have jurisdiction? Not just them alleging it, like they told Tony. The MLC 440, Section 1, PA, is a plain English about how illegal it is for a corporation representing another corporation or anyone outside of itself, i.e. jackass attorney names here, attorney at law. The court would lack personam jurisdiction if there is not a nexus between the parties. Don't understand what persona means. It's talking about personal jurisdiction, right? And all attorneys came under the judicial branch and the judicial officers under the Supreme Court, which means they could only represent the court and not the people. So why are you people still hiring attorneys? They could only represent the court and not the people. It's right here. What am I doing? I'm showing you the law. I'm giving you the law for educational purposes only, of course. They can't represent the people. The state or bring forth evidence thereof. Defendants challenge personam jurisdiction for the record. Any explanation to the above mentioned matters must be done on a point-by-point basis with verified facts and referred in law, legislative acts, federal and or state constitution. The response from the party petitioner plaintiffs asserting proper jurisdiction must be sworn to under the penalties of perjury of the United States of America that the response is true and correct, certified, notarized, and must be able to be understood by a reasonable man or woman. Should understand. Understand why we're doing this, Tony? So if they lie, we could get them arrested under the penalty of perjury. Pleadings of the party shall not be dismissed for lack of form or failure of process. All pleadings as any reasonable man or woman would understand, and in support of the claims, I submit the following. And be it further intact that no summons, writ, declaration, return, process, judgment, or other proceeding in civil cases in any of the courts of the United States shall be abated, arrested, quashed, or reversed for any defect or want of form, but the said courts respectively shall proceed and give judgment according as the right of the cause and matter in law, and shall appear unto them, without regarding any imperfections, defects, or want of form in such writ declarations or pleadings, return, process, judgments, or course of proceedings whatsoever, except those only in cases of demur, which the party demurring shall specially sit down and express together with the demur as cause thereof. And the said courts respectively shall have, may, by virtue of this act, from time to time, amend in every so imperfection, defects, and wants of form other than those only which the party demurring shall express as foresaid, and may at any time permit either of the parties to amend any defects in the process of proceeding upon the conditions as the said courts respectively shall, in their discretion and by their rules prescribe. Judiciary Act of September the 24th, 1789, Section 342, First Congress. Again, you could actually ascertain all of this in my books by going to the website, www.truedisciplesofchrist.org/shop. Get the books and DVDs, get your minds right. So now, that concludes my special appearance to challenge jurisdiction. Now, I actually also attached an affidavit, as I stated. And could you take it from there, Terrence? You still on?
Yeah, but I can't see the screen. I'm just on my. I'm just on the house phone.
All right. Hey, headache, man. Doc Chabé declare this to be true, correct, and complete. Subject matter jurisdiction is the authority of the court to hear and make determinations in a court action. Number two, without subject matter jurisdiction, good brother Tony, all orders and judgments issued by a judge are void under law. So if they don't have jurisdiction, out of here, like last shit. Number three, the subject matter jurisdiction. All orders and judgment issued by a judge are of no legal force. Without jurisdiction, you have nothing, buddy. Number four, every act of the court beyond the subject matter jurisdiction is void. Number five, when a court's power to act is controlled by statute, the court is governed by the rules of limited jurisdiction. Number six, courts exercising jurisdiction by statute must proceed within the structure of statute. Do you understand? Statutes are written with only limited jurisdiction. Emphasis added there. Statutes do not necessarily apply to a sovereign or a secure party creditor, so that you can understand. Special statutory jurisdiction is limited to language of the act countering it. As regard 10 above, the court has no power from any other source. The authority of the court to make an order must be found in the statute. A judge not have subject matter jurisdiction, then the law states that the judge has violated the law. The judge has violated the law. A judge have not subject matter jurisdiction, then the law states the judge is a trespasser of the law. What am I giving you? I'm giving you the law. 15, a trespasser is one who has committed unlawful interference with one person's property or right. It's a trespasser. Number 16, The law presumes nothing in favor of the jurisdiction of a court, exercising special statutory powers, such as those given by the statute under which a court acts. Number 17, the judge has a duty to continually inspect the record of the case. And if subject matter jurisdiction does not appear from the record of the case, then the judge has the duty to dismiss the case as a lacking subject matter jurisdiction, Tony. Number 18, a judge acts in any case in which the judge does not have subject matter jurisdiction. That judge is acting unlawfully. Number 19, a judge should not act in any case which the judge is acting without judicial authority. Number 20, judge's allegations, Tony, judge's allegations that he or she has subject matter jurisdiction is only an allegation. Isn't that what they told you? Come on, man. Stop falling for the okie doke. Learn the law. 22. Actually, 21. If a judge has no subject matter jurisdiction, those who advise the judge or execute his process are trespassers. Number 22. The judge who acts without subject matter jurisdiction is a common criminal. A common criminal. And number 23 is anyone who acts in conjunction with a judge who acts without subject matter jurisdiction is a common criminal. In response to this affidavit must be done on a point-by-point basis in writing or accept a default for their actions, and default will not be a full dismissal of any and all related, a default will be full dismissal of any and all related charges, as well as specific charges in the above case. Courts. Time for response shall be 7 days. We're going to give them 10. We want to make sure we give them due process of law. We're going to change this to 10 days from service date. I declare that the statements are true to the best of my knowledge. Respectfully submitted with explicit reservation of all of my rights, and I have waived none of my rights at any time or any reason. Tazadak Shabe and propria persona sui juris, not pro se. Emphasis added. Authorized beneficiary for Tazadak Shabe. And there's the notary signature block. And so I could almost guarantee you, Tony, if you go in with this, you should be victorious. So the choice is yours. Hey, I thank everyone for tuning in. A lot of free information here. Again, I would highly, definitely appreciate. Let me put the Cash App in the room again. You could donate right there on Cash App. We appreciate your donations. Definitely appreciate the thumbs up. We'll also appreciate you helping other people that are in desperate need of some help. I understand how, fearful it could actually be going into a court and you don't have knowledge of this. You're going to feel extremely uncomfortable. The more knowledgeable you are, the more comfortable you will be. Also, let me put the website here. So here's a website. You want to get the books and DVDs that would definitely help you out. You can find most of what we cover here today in my books and DVDs. You ask me which one, get all of them. Can't afford it, get it anyways. Because in the end, it's definitely going to help you out. You know, how many times I heard people tell me I can't afford that, it's really expensive. And then they turn around and say, hey, well, your book saved my life. Yeah, your book saved me thousands of dollars and so on and so forth. So, hey, Tony, if you use this, I feel very strongly that you will come out victorious. I feel very strongly if you read this, what I just covered for educational purposes, and you understand what was said in here, Can't lose, man. You can't lose, man. I do this for real. And so I appreciate you all for tuning in. And so with that, I'm going to say shalom. And again, we definitely appreciate you donating and thank you for listening. And with that, I'm going to say shalom. Most High in Christ bless. And I got to add, the Spirit of the Lord must be in this. If you don't have the Spirit of the Lord with this process, it won't work for you. Because we're saved. Your redemption comes through the blood of a Mashiach Yahushua, the one that you call Jesus Christ. This is what all of our redemption comes from. You got to understand that to understand why this process works. We're saved by the blood of Hamashiach Yahushua, the one that you call Jesus Christ. So with that, I say peace to all the dead haters after war. 2 fingers. I'm out. Shalom.
Shalom.